trying to elicit answers from the various stakeholders.
Farouk Lawan was one of the Nigeria's most vocal federal lawmakers, but a bribery scandal cut the diminutive Kano politician down to the level of his literal size. The man who was asked to investigate the massive fuel subsidy fraud in 2012 turned around to demand for bribe to exclude one of the companies he was supposed to investigate. He was caught on camera collecting $500,000 bribe. Despite the abundant physical evidence, it took about 9 years before he was found guilty by a trial judge. Under Nigeria's justice system prior to the Administration of Criminal Justice Act 2015, a trial judge who starts a case must complete it, otherwise the case starts afresh if another judge takes over. In Lawan's case, 3 different judges handled it after the first one was elevated to the Court of Appeal bench and the second withdrew due to accusation of bias by the defendant. Lawan was finally found guilty by Justice Angela Otaloka in June 2021.
We made it very clear.
The situation in Lawan's case is what plays out in multiple of such cases across the country. The faultiness forced policymakers and the legislature to introduce the Administration of Criminal Justice Act 2015. The Act contained hundreds of pages to fast-tracking criminal justice.
So under the Administration of Criminal Justice Act, a lot of provisions have been put in there for speedy dispensation of justice. And I think to a very large extent that has worked. The example is the provision of Section 306 of the Administration of Criminal Justice Act. That provision prohibits steering by proceedings in the course of criminal trials, and that to a very large extent has really helped in speedy dispensation of some of these high-profile cases. Before now, that was not the case. I'm also aware that also in the same act there are provisions that limit the amount of adjournment that can be asked for during the course of trial. So I think it can also be looked at in that regard, not necessarily having to put a timeline like the way we have with political matters. But if we have provisions, maybe in respect of our civil procedure case, civil matters, just like the same way we have with the Administration of Criminal Justice Act, we have provisions that can be put in place to address some of the challenges that the things about delay. I think that would be a long way to address the issue of delay.
The Act also recommends the digitalization of the court system to do away with manual recording of proceedings and improve access to information and research.
AI is the only solution in terms of case management, in terms of case organization, in terms of scheduling, and in terms of delivery of justice. Justice must, cannot be slow. Justice must not only, have what you call a speedy boat. It must fly. That's the only way that some people have been waiting in remand prisons for 5 years, for 10 years, for offenses which even upon conviction is not more than 3 years penalty. So this is just unfair, this is just unjust. So for our court system to be revolutionized and for our court system to be in line with modern best practice, we need to adopt technology, we need to adopt AI and all the tools and all the benefits and opportunities that are there.
Slow justice administration is not only at trial courts, but also at the apex courts, where appeals span over 100 years, while litigants may have died while waiting for justice. This has spurred the advocacy for amendment to the Constitution to limit the kinds of appeals that should get to the Supreme Court.
There are multiple factors that contribute to delay in trials. And then you ask the question, should some of these matters, particularly in terms of appeal, be going up to how far they go? Yes, I don't think, particularly the interlocutory appeals, should not be going up to the Supreme Court. If we now structure our jurisprudence and the rules of court, particularly the criminal procedural rules, in such a way that even if a decision is given at the interlocutory stage, it can still be incorporated into the final appeal, like we do in election petitions. You can say, okay, raise your objection, but we will admit it in the interim. When you go on appeal or during the final addresses, it will be taken together. That's what is done in to short circuit the time management in election petition matters. We can introduce that into the criminal trial procedures, but we must find a way of managing the time so that the time spent on each case and the time for awaiting, particularly those who are still awaiting a trial in the courts, or even who are awaiting the determination of the appeals arising from a conviction that had been held.
Similar amendments have positively impacted election cases, and constitutional time limits have ensured that pre- and post-election matters are dealt with in less than a year. Chibuzo Okezie, AIT News, Abuja.